discovery is the process by which we go and get the information from witnesses to a particular piece of litigation and understand what happened in that litigation. And a long, long time ago, as you can see from the slide, we used to do that in paper. When I started practicing, we would go to custodians and witnesses who were involved in the lawsuit who had information, and we would sit down face-to-face with them and say, okay, let's talk through your story, let's understand what happened. And they would reach in and pull a file folder out of their desk drawer and have all of the papers that were associated with that particular project. And it could be a whole drawer full or 5 drawers full, or it could be a small file folder. But nevertheless, we had all of that information right there. And different people would have different pieces of that information, and we would put it all together. But what we didn't have to do, that we now have to do with ESI, is to sift through huge file folders of information to be able to find what was relevant for that particular project or case or what pertained to that case. Now what we have is information that is spread across a disparate number of systems. So if I came to you and said, there's a breach of fiduciary case about the sale of this piece of our business that we engaged in 6 months ago, where would you have to go within your litigation IT infrastructure to be able to find all of the information that would be about that? Who were the 10 or 15 or 5 or however many people that you would have to talk to? And how many places would they have information? They'd have information on their email systems. They'd have information in SharePoint databases. They'd have information in spreadsheets. They'd have information all over, on hard drives, on networked areas, places where we have to really dig down into and not find just the one piece of information, but filter through everything that's there. So the difference now is that it's just a phenomenally different process, and lawyers have to really rethink how they're engaging in electronic discovery. And there's a lot of preparation that can go into businesses being prepared to deal with electronic discovery that can minimize the costs and risks associated with it. This slide kind of outlines for you what is the biggest takeaway for you to go back to your organizations with in understanding the concept of electronic discovery as it matters for legal purposes, and that is that a party has a duty to preserve. That means keep any information that may be responsive when it knows about or reasonably anticipates litigation. And in the context of board communications that we're talking about today, you need to keep in mind that when your board is making a decision that they have been advised and that they know is likely to result in litigation, then any of the information that they create as a result of the decision that's made around that particular project is going to likely be discoverable information. And you need to think about that in advance, and you need to plan for it. And you need to think about how that information is being communicated as to whether or not it will be captured, i.e., is it in email, is it in instant messages, is it in annotations in a board portal, where is it, how is it structured, and is it discoverable? Thinking about the challenges that we face with electronic discovery and the volumes of ESI. And it is really that volume that is the huge problem, because the more ESI you have, the more cost you're going to be looking at in dealing with electronic discovery. And any steps that you can take to prepare, and we're going to talk about a number of those, are going to help you reduce the cost that's going to be associated. It's going to be very difficult to attach an ROI to it. So in order to be able to undertake programs where you put proper e-discovery measures in place before litigation or planning for changes to board communications, you need to have C-suite buy-in. You need to have upper-level management buy-in before you're ever going to be able to affect the kind of change you need to, because a lot of what you're talking about is rethinking communication strategies within the organization. So these rules and understanding the notion of e-discovery, the duty to preserve, and the processes that we're going to talk about a little bit today are very important for organizations to understand generally. Even if you have a very small litigation portfolio or are not involved in litigation at all, it's important for you to understand them, because when you're a smaller organization or you have a membership, one large case could be the undoing of the organization from a cost perspective, based on your requirements to respond. So the notion and the planning stages that we'll talk about are crucial to making sure that you keep those costs low.